Morning, everyone. My name is Sterling Higa, Chairperson of the Authority. I'd like to call to order the February 5th, 2025 public hearing of the Hawaii Community Development Authority. Time is now 9:01 a.m.
Thank you, Chair. The Hawaii Community Development Authority is holding today's public hearing both virtually on Zoom and in person. The Zoom link details were included in the public hearing notice. Therefore, members of the public are welcome to join us on Zoom or at the physical meeting site at the American Brewery Building, 547 Queen Street, second floor, boardroom, Honolulu, Hawaii, 96813. The HCDA communication staff is hosting the Zoom portion of this hearing. Once this public hearing begins, everyone will be muted for clearer audio. Board members, if you have any comments or questions, please unmute yourself to speak. It is important that all individuals clearly state their name each time prior to speaking. This is a public, in-person and virtual public hearing, so to prevent any distractions, if you are attending virtually and you are not a board member, staff member, or HCDA's Attorney General, please turn off your video during the meeting. If you are providing public testimony, your name will be called accordingly. If you are attending in person, when your name is called, please come to the front of the room. If you're attending virtually, you may click the raise hand button to indicate that you wish to testify. Each testifier will then be enabled to unmute their microphone and turn on the video in order to provide testimony. In either case, please clearly state your name and affiliation and proceed with your testimony. Oral testimony will be limited to 3 minutes and will be accepted only on matters directly related to the public hearing subject. If the authority's connection for the remote meeting is lost, the hearing will be recessed until the connection is restored. If the connection cannot be restored within 30 minutes, the hearing will be reconvened on Thursday, February 6th at 9 a.m. at the same physical location, virtual Zoom link as today's hearing. Thank you. Chair.
Great, thank you. Let the record reflect that the following members are present. Vice Chair Ishii.
Here.
Thank you. Secretary Lidstone.
Here.
Thank you. Member Miranda Johnson is excused. Member Anderson.
Here.
Let's see.
Yeah.
Thank you. Member Evans.
Here.
Member Stripes.
Here.
Thank you. Member Yamashita. Well, I think he's there.
Oh, he's there?
He's in the waiting room.
Yes.
He's coming in. We'll mark him as present. Member Tsuji.
Present.
Thank you. Member China is excused. Member Sakota.
Here.
Thank you. Member Gordner.
Here.
Thank you. Member Leong. Mark is excused for now. Member Light.
Here.
Thank you. Member Kabibi. Mark is excused for now. Member Yamasaki.
Here.
And if you want to go back to member Yamashita.
Yep. Member Yamashita. Oh, and there looks like we go. Member Yamashita, are you here? And member Kabibi.
Yes, I am.
Thank you, Yamashita.
Member Kabibi is here as well.
Thank you, member Kabibi.
Chair, we have quorum.
And almost perfect attempt. Thank you. Do you want to talk to the legal basis?
Yeah. Individuals from the public were requested to provide verbal public testimony on the administrative rules on standby and then will be permitted to provide testimony respectively. Legal basis and purpose. Today's public hearing is being conveyed under the provisions of Hawaii Revised Statutes, sections 206E-281 to 294, section 1-28.5, section 91-3, section 92-41, and 206E-5.6, and chapter 15-219 of the Hawaii Administrative Rules to consider the following matter. 99-year leasehold program administrative rules. The Hawaii State Legislature through Act 97 Session Laws of 2023 established the 99-year leasehold program. The purpose of this program is to determine the feasibility of developing one project consisting of low-cost leasehold residential condominium units on non-ceded non-ceded state-owned land located near public transit stations for Hawaii residents. The proposed administrative rules contain: one, a description of the 99-year leasehold program; two, eligibility to purchase requirements; three, the process of marketing and selling of leasehold condominium units; four, the requirements for the resale or transfer of leasehold condominium units, enforcement and penalties; and six, provisions upon the foreclosure of a leasehold condominium unit. No native Hawaiian traditional or customary rights or practices have been identified that may be impacted by the adoption of proposed administrative rules. The authority is conducting today's public hearing to present the administrative rules and collect public testimony. There will be no decision-making on the proposed amendment rules today. A public hearing notice was published in the Honolulu Star Advertiser, Maui News, the Garden Owl, Hawaii Tribune Herald, and West Hawaii Today on Thursday, January 2nd, 2025. Chair.
Thank you, Craig. Let me briefly explain our procedures for today's public hearing. First, HCDA staff will present its report. Following that presentation, board members will have an opportunity to ask questions or provide comments. Finally, we will take public testimony in the order that individuals have signed up. Individual comments will be limited to no more than 3 minutes. Only members of the authority will be permitted to ask questions of the public. Since each authority member has or will be given a copy of any written testimony that you may have provided, please refrain from reading your written testimony and instead summarize your comments in the time that you have available. When you are called, the communications staff will unmute your mic. Please clearly state your name and any organization that you are representing. I will be acting as the presiding officer for this hearing. Are there any questions as to our procedures? Seeing none, we'll now begin our proceedings. Mr. Deepak Nupane, Program Specialist 5, will now present the staff report.
Thank you, Chair and board members. The staff report is in your packet. I'll just briefly summarize it. As it provides the staff report provides the background, so I won't go over it. It's mentioned that in May of 2024, the authority authorized the executive director to initiate the rulemaking process. So we are here. We have met with the stakeholder community members. We had a meeting here, and then we also, the executive director and I presented the concept, not the rules per se, but the concept of the statute and all to Ala Moana, Kakaka neighborhood board, and also to the Makiki Kapolei neighborhood board in August of last year. The public hearing notice for the rules was published in January 2nd, 2025. And today is, as the executive director mentioned, the presentation hearing for the rules. The rules itself, specifically for the leasehold program, sections 206E, 283, 284, and 292 provide for rulemaking for specific provisions of the statute. Copy of the draft rule is provided in your packet. I will just summarize what it includes. The title of the rule is the 99-year leasehold condominium program, promulgated as Hawaii Administrative Rules, Chapter 15-223. The rules itself, section 1 through 6, establish the purpose and intent of the rules and also provide for administrative matters. Section 18 and 19 establish the eligibility to purchase the condominium units developed pursuant to the program and owner occupancy requirements. Sections 31 through 34 establish the procedure for marketing and sales of the condominium units. Sections 46 through 50 establish the procedure for resale and transfer of the units once they are initially sold. Section 62 through 64 provide for enforcement of administrative rules and penalties in case of violation of the rules. Section 76 and 77 provide for the procedure for foreclosure, sale in terms of, in case of foreclosures. So that's just a summary of the rules, and I'm available to answer any questions that board members may have.
Thank you. Members, any questions on the staff report?
Deepak or Chair,
Yeah, please, Member Evans.
Deepak, in the copy that I received, sections 65 to 75 were reserved and not shown. And I know that one of the written testimonies refers to section 65. Is there another place where that might be available?
Section 65. Let me look through the rules.
Section 65 to 75 are reserved. Member Evans, what testimony were you referring to?
Bill Ewan's testimony, William Ewan's testimony.
That's probably a typo then, and it's just.
Maybe I can clarify, Member Evans. So if you go into the attachment to Mr. Ewan's testimony,
Yes.
there is a suggested section 65 that he has put in. So it's marked in blue as a proposed addition to the rules.
I see.
But you are correct that there are 66 through 75 or 65 through 75 are reserved. And I don't see in any of these materials any written rules there.
Thank you. That clarifies for me. I appreciate that, Chair.
Yeah, I think he was marking up a draft. Member Evans.
Yeah, we reserved this block of sections in case we have to go back and revise the rules, so we can easily add another section. So that's where you'll notice that after each chapter, about 10 blocks of numbers are reserved for in case we need to use it in the future.
Right, this is just a legal procedure so that you don't need to renumber.
Renumber
everything.
Yeah.
Yeah, no problem. I just wasn't sure why the testimony was referring to 65, but now I am clear on it. Thank you very much.
Thank you, Member Evans. Members, any other questions on the rules or for the staff? Member
I got a
Schritz
question.
and
I got,
sure, Member Tsuji, and then we'll go to Member Schritz.
okay, the question I had was at the end of the 99 years, the building would be offered to the lessee, or would it be revert to the landowner?
Member Suji, the statute is clear that after 99 year, the property reverts back to the state. There is no provision for extension of the lease after 99 year.
Okay.
Thank you, Member Tsuji. Member Schritz.
Thanks for this presentation. I think there's a lot of good considerations in here. I had a number of, I guess, comments and questions, some of which might overlap with the testimony that I kind of was able to skim through before the meeting. So maybe I'll just kind of walk through briefly, but to start off in the definitions, I saw urban redevelopment sites is tied to essentially the rail, but it's using a definition of a mile radius. Common practice for TOD is a half mile. So I would suggest amending that to state the site would be within a half mile.
I will go back and check member sites. I believe that definition came from the statute.
Oh, okay.
It's defined in the statute, so I probably copied verbatim.
Okay.
But I'll go back and check on that.
Okay, thanks. And then under the eligibility section, I think this might have been raised, but I also agree that I think there should be some sort of administrative process to extend the holding of real estate past the 6 months if under some like undue type of circumstances, if like the market doesn't allow the owner to be able to sell within that time period, that the executive director could have some discretion over an extension. And I wasn't sure how the enforcement of this eligibility would be carried out. It seemed like there was some enforcement covering other sections, but I don't know, maybe that just needs to be clarified. Whether that also applies to this eligibility section if they become non-compliant, like through that holding past 6 months or what have you.
Sure, I think we have comment from member
Quarter.
Gordner too, and some of that, so
Yep.
I intend to, and I'll be following up with the member on that. So,
And
well, yeah, go ahead.
it was the intent to limit these units to certain area median income groups? Because I didn't see that mentioned.
There is no provision for that in the statute, and in conversation with Senator Chang, I believe the intent was not to put any kind of income qualification.
Okay. Under the owner occupancy section, there's a statement that the owner submits annual affidavits. Was this intended to be notarized? It looked like later in other sections, it was saying submitting just like an acknowledgement to the executive director. So I don't know if that's just something you're intending like to be signed and submitted annually, or maybe like the initial one is notarized.
Yeah, I haven't given much thought to that,
Okay,
frankly, so we'll look into that, whether notarization is necessary or not. Because currently too, for reserve housing, I think it's just an affidavit
okay.
is required, so.
Yeah, so a lot of my comments are just, to provide that clarity and consistency in other sections where it's similarly used.
If I may, just add some, Chair, I think member strikes like, some of what you're seeing in the rules. Are a reflection of the parameters of this pilot program that was laid out in the statute. So, and especially with respect to your comment about maybe allowing some extensions of time, grace for certain things to divest property is well taken. But I think we're gonna have to look back and then it's challenging because it's almost like having a test parameters for this.
Yeah, and also, some of those I have to go back to the statute and look at the language of the statute, whether there's flexibility on that, because the statute provides for flexibility in terms of, if they have to move to if they are in the military or those kind of things. Right, but there is nothing in the statute about extending the 6-month period and all, so I have to get together with the deputy AG and talk through the legality of it too. Since that, on the notarization and all, some of it probably can be handled administratively. And not have it in the rules.
It just seems like a burden on the resident to have to go through the notarization every year instead of, just submitting a signed
Yeah.
form. Maybe like the initial one could say, they intend to abide by this and so forth. And then
The intent is to just to, provide something that gives HCD the opportunity to check that person is still.
Yeah.
Living in the units.
Yeah, and I would also, so to add to that, we'll look into it, member strikes, but. I mean, when somebody gives an affidavit, I think they're attesting under penalties of perjury too,
Yeah.
so that gives some, I think it's more to. Make the signers aware of what they're signing and what they're attesting to. And we'll look into the notary, whether it's really required or an affidavit, under penalties of perjury is sufficient.
Okay. And you had mentioned that after 99 years, the leasehold reverts back to the state. I think just some clarification throughout, like on the sales of condominium units section and talking about, transferring ownership after the initial buyer. To just state that the length is the difference between at that point and up to the 99 years of the initial purchase. So that they're not assuming they get another 99 years. I think it was a little unclear from the language and the rules.
Okay, we'll look into that too, whether that's. The deed for the unit care of that or whether that needs to be spelled out in the rules.
I would also think member strikes that, in the, buyer disclosure documents, they will, all of that will be spelled out, for buyer disclosure purposes as well,
Okay.
and in the condo documents as well.
Under the resale of condo units, it wasn't clear to me, who's responsible for finding the eligible purchasers. So initial sale, it's either by the developer or HCA who's finding and I guess qualifying. And so, when it comes to the resale, it wasn't clear who assumes that role.
I think it is the program, HCDA's program, so I think it's, it's implicit that it's HCDA that's going to qualify the buyer at resale side. Now, whether HCDA is going to hire an outside consultant or a realtor or something like that, that's going to be decided administratively later on.
So it'd be, in that scenario, the seller, I guess the seller's real estate agent would be responsible for finding
Finding.
a qualified applicant, and then HCDA would be the ultimate
Yeah, and
determiner of.
yeah, the seller's real estate agent is going to submit all the documentation to HCDA.
Okay,
And HCDA is going to review it and make a determination whether the buyer is eligible or not.
okay. And I think member Gardner had the same comment, but on the resale, there is some clause about the former owner cannot qualify for purchase of another condo unit, and I kind of find issue with that in that if they are starting out at, like in a studio or one bedroom, have a family over the years and need to move up into a bigger space, why should they be disqualified from selling the smaller unit and going into a larger unit?
Yeah, I noted that. Yeah,
Oh,
we'll look into that.
Okay.
Yes, that wasn't the intent. I think the intent here was that, if someone just wants to sell and then disqualify them for purchasing other units later on. So we'll make that distinction.
Okay, perfect. Thank you, member Strites. Member Sakota.
Good morning. Every time I read through this type of presentations, I'm a little bit concerned just about the administrative cost or the administrative burden on the HCDA. In my mind, I'm not sure how these things are working right now, but in my mind, I have this image of a lot of paperwork, a lot of paper getting transferred into computer systems. Is there any strategy or current systems where a lot of this administration and enforcement and application is actually online?
Online.
Well, there's no paper involved,
Yeah, I mean, I remember Sakota, I understand your comment and I understand your concern. I think that's a comment that we've, gotten from you several times over different issues. I'm always also concerned about administrative burdens. I think simply a lot of the documents, do come online, probably through email versus paper, but the review of the documents still necessarily either staff is going to have to do it, or as Deepak mentioned, we would have an outside, like a consultant sort of helping third party to review those. But either way, I think staff or consultant, a vendor is going to have to review it.
Yeah, currently, member Sakura, for the reserved housing, it's usually, well, most of the time it's the developer who goes through all of that and submits it to HCDA staff. And the staff reviews it to make sure that all the documentations are there, and then, the qualifications look fine, that no one is trying to, game the system. For going everything electronically, I don't know if there is enough volume at this point to just, spending the resources to make it all electronic. But if this kind of programs become permanent and they're very successful, and we are producing, instead of 300 units, we are producing in the thousands, then probably it's a good thing to look at making all of this electronic.
I mean, part of my point is just the administrative costs are going to continue to escalate, and demand for more people, handling paper. And I'd like to see sort of the HCDA take a more forward-looking strategy in trying to reduce not only the administrative burden, but also moving and using more technology to just generate more efficiencies.
Good.
That's it. Thank you.
Member Sakota.
Thank you, Member Sakota. Member Kabibi.
Yes, good morning. Thank you. My comment is related to not having an income guideline defined, because if you're looking at the governor, the purpose of the governor's action is, it says for low cost leasehold residential. So normally you would think low cost is going to be associated to a particular type of income. And if you don't define that, I think that's going to cause some confusion. And I guess as an organization that works with representing low income individuals, I think that might be something that we should take a look at. That's just my opinion. Thank you.
Thank you, Member Kabibi. I believe we left it out because there is nothing in the statute that requires income qualification. And also in the meetings that the executive director and I had with Senator Chang, that was his bill that became Act 97. He had been very clear that he did not want any income qualifications. I believe the controlling mechanism here becomes owning real estate property. That if you own this property, you will not have any other residential or commercial real estate holding. And I believe, the thinking was that probably in a roundabout way puts restriction on income, high.
Member Kabibi, maybe if I can add some additional context without speaking on behalf of Senator Chang, but just sort of summarizing his general public comments and the thrust of his Aloha Homes plan. Senator Chang, for years, and this leasehold project is sort of the manifestation of that, has advocated for building revenue neutral leasehold housing. So because it's revenue neutral, typically these aren't actually going to be low income housing units, although they potentially could be. Those housing units would be provided by alternative programs like the low income housing tax credit finance programs that the state offers. These units, at least as far as to be judged by Senator Chang's public comments, are intended for that sort of gap group, roughly between 80% area median income and 140% area median income, that typically don't qualify for either federal or state subsidies, but in recent years have been addressed through programs like the Rental Housing Revolving Fund Tier 2. So I think the intention of this program is, even though low income is mentioned in the sort of preamble of the bill, is actually more focused on that middle income housing. And so part of omitting a statutory definition is actually to give more flexibility, because one of the questions would be, say there's a mixed income leasehold housing project that includes some units that are even above 140% area median income, would HCDA be able to build those? But to your point, Member Kabibi, because these rules govern at least just this pilot program for now, I would imagine that the staff at HCDA would work in close consultation with the board to amend the rules as we go through a few of these pilot projects, just to make sure that we're delivering, exactly what the legislature intends for this program to administer. Okay. And
Yeah, and I think those, to add on to it, I mean, that owner occupant requirement, no other, property, either investment or otherwise, I think reflects the intent behind this, that these are really units or homes for, home's sake. They're not intended to be an investment property. This is meant to be home for home's sake. And I think that's what we've carried through to this. Now, what happens after, you know, if this program is not successful, in other words, it's not feasible, Senator Chang may decide to do something else next time with different parameters, but right now, we're dealing with the test parameters that are in Act 97.
Member Kabibi, do you have any other questions, or is that's helpful context?
No, I just wanted to thank you for that explanation that clarifies the questions I have. And I do appreciate that you're going to revisit the, being able to upsell. So if you sell the unit and be able to buy something else, because that's a lot of how people with median or lower incomes can, improve their living situation. So thank you for that.
Thank you, Member Kabibi. Members, any other comments or questions? If not, I have a couple. Member Gordner.
Yes, you all have my written testimony, so I won't go through it line by line, but for those who may not have been able to read, I do want to highlight a couple of things I think are significant, and then I do have one question near the end about the foreclosure provisions. So, a couple of things that I saw just to help the program work better. In subsection 31, allowing the executive director to set some kind of cap. I don't know if you all have seen, but for instance, when the public housing rolls open, as they rarely do intermittently now, you could be bombarded with thousands of applications. And I wouldn't want staff to end up in a situation in which, in order to, fairly treat everyone who applied, they would need to comb through and make eligibility judgments, whether HCDA or the developer, on thousands of applications, as particularly if some could be spam or completely ineligible. So flagging that as, I think, a significant recommendation. And then in section 33 for the application intake list, since the staff member mentioned the possibility that we hope this program will expand, and there's already been talk about administrative burden, I think it would make sense to allow for cross applications in some sense. This is something that we've seen at the federal level, for instance, an attempt to reduce the burden on applications for people participating in these programs. And so the basic idea that I introduce is that, if you apply to one program and you qualify for that one program, you qualify for all within a certain specified time period. I also think it's important here in the application intake list in particular to retain these records for policy evaluation and research use, because this is a policy pilot. I think it's it'd be very important for us to engage with the research community. And in order to do that, we have to have some sort of records retention policy, not only for the people who are selected, but for all of the people who are applied, so that researchers could use kind of the gold standard methods of random assignment in order to evaluate what happens, what changes in a person's life, depending on whether they're selected for the program or not. And then the last kind of what I think is the most significant of my comments is in 48, in the right of first refusal and the calculation. I saw that the other testimony recommended some language here as well to clarify the numerator and the denominator. I just want to highlight that the CPI, as an inflation index, it includes a very large basket of goods and services. And I think what we're getting at here is that we specifically want the resale price to move up no more than the way that home prices move up over time. And for that, you do not want the overall CPI for urban Honolulu, which includes things like gas prices and eggs and so forth. You would want the specific owner equivalent of rent. So I include the specific series in my testimony, but I think that's a significant difference. And so those, I think, are the highlights. There are a couple other tweaks I mentioned that might make things work a little bit better. But that brings me to my question, which is around subsection 76 concerning foreclosure. It's not strictly about foreclosure. It's kind of a broader question around the availability of mortgage financing for these units. So, the one thing that I saw in the foreclosure in subsection B is that there is a provision that would allow a unit to fall out of the program in some sense if it's foreclosed on, because the bank would then be able to offer the unit to buyers who otherwise would not be eligible under the program, right? And my sense is that is probably related to just foreclosure provisions and the concerns of the banks about, lending on these properties if they don't have that kind of buyer pool to rely on. So I just wanted to give staff an opportunity to speak to if they've spoken to bankers, mortgage bankers, whether they see any issues with lending on these units as a result of the limited pool of buyers, either in the initial eligibility or in the event of a foreclosure. Thank you.
Yes, I mean, I haven't talked to bankers and mortgage, guys, and this particular rule, but this was based on my experience working in the reserve housing. I had many conversations with local bankers on the reserve housing rules when we amended the rules like maybe 10-15 years ago. And one of the feedback that came back time and again was that, ability for the bank to be able to sell the unit. So if you look at the current Kaka'ako reserve housing rules, we have same provision. Once it goes into foreclosure, actually in Kaka'ako reserve housing rules, then they only have to notify HCDA of it. There is no buyback by HCDA provision there. And then the unit goes out of regulated term. And the bankers were very adamant that, if we don't have that provision, then probably, they will not be able to provide a mortgage for that kind of unit. And that's why I reflected, based on that experience, I took the similar language for this one, where, within the 5 years, we put in a provision that if it forecloses, then even the bank has to give HCDA the first opportunity to refuse that mechanism. Now, I have to think through and maybe talk to some mortgage brokers and bankers on whether we could put that provision for any, even after 5-year buyback period of the banks, because the way I'm looking at it is that if the HCDA, I don't think it hurts the banks to give HCDA the first opportunity to refuse, because all they care about is getting their mortgage loan paid back, right? So we'll talk about that with the bankers, but the feedback that I had from before talking to a lot of the local bankers was that, they won't be able to finance the unit if they don't have that kind of flexibility.
Member Gordner, we'll let you finish your chain of questioning, and then Member Evans.
Yes, thank you. Just a brief response. All of that makes sense to me. I think the risk of a unit falling out of the program is it would be significant, right? And not significant in the sense that it's going to happen often, but significant in that we really would not want that to happen. And so perhaps as part of the administration of this program, we could think about maintaining some sort of reserve that would be available to actually exercise that right of first refusal, let's say based on the typical foreclosure rate of the reserved housing program. Something like that, I think, and maybe the reserved housing program could be amended like this as well in the long run. But I understand that the right of first refusal, that's nice, but if we don't have several $100,000 lying around, which is not typical for a lien public agency, then that right doesn't mean very much to us in the moment. So something like a reserve, not necessarily that it needs to go in the rules, but might be appropriate to consider in the long run. And might give the bank some additional assurance as well, right? Okay, thank you.
Thank you, Member Gardner. Well, duly noted.
Member Evans.
Speaking to the same issue, Hawaiian Homelands has 99-year leases, and they have had challenges over the decades getting banks to participate in issuing mortgages to their beneficiaries who are awarded either a leasehold lot or a leasehold turnkey house. And I think if I recall, DHHL had to guarantee the mortgages before the banks would participate. So I think looking at those restrictions from a lending perspective is really important to the success of this, to achieve Senator Chang's goal, which is to have more housing available for owner occupants who are residents of Hawaii. Thank you.
Yeah, Member Evans, I've talked to developers and also with, some mortgage brokers, and for now, it looks like for the first several iterations, getting a mortgage is not a problem for leasehold property. Typically, a bank looks at, 30 plus 5 year kind of thing. So as long as it's that, but the issue, it'll become an issue when you get to year number 60 or 70, and you don't have more than 35 years left on the leasehold, then that may be a problem. And that's,
Thank you, Member Evans. Members, any other comments or questions? If not, I'll have a few comments. Okay, a few comments. So the first one on technology, I think bat signal out to Christine Sakuda, the state's Chief Information Officer. This particular problem of having to deal with potentially thousands of applications is one that HCDA should be leaning on the sort of IT professionals at the higher level of the state to deal with. I don't think it's something that we should be worried about solving in-house, but it is something, as Member Sakota and Member Gordner have pointed out, that we should be thinking about to future-proof this system and reduce the burden on our staff administratively. There's also a potential there for Christine Sakuda to lead the solution of this problem for multiple state agencies that deal with this recurring problem, including HHFDC. So that signal to Christine Sakuda, please pay attention to this and make time for a meeting with HCDA. The second thing on the financing, I have specific recommendations of people you should meet with. So the first is Jeff Gilbreth, who is the executive director of Hawaii Community Lending. They are maybe the most prominent and one of the most successful sort of programs that helps people access financing, especially non-traditional financing for things like Hawaiian Homelands. So Jeff, more than maybe any other person in the state, would be familiar with exactly how to structure these kinds of administrative rules to increase the pool of eligible buyers who will qualify for mortgages. And the other person at Hawaii Community Lending who would be relevant to talk to is Billy Piper, Pieper. He serves as the board chair, but he also works at American Savings Bank. And Billy and I have had multiple conversations about how do you structure creative financing products to get more people into home ownership. I think it is vital for HCDA to be working with these kind of people who are on the cutting edge of lending and getting people to qualify for mortgages, because the marginal difference between qualifying 10% more buyers for a project like this, on the margins, buyers who wouldn't qualify given the current rules if we marginally improve the rules, we might increase access to this program for literally thousands of people. So getting these rules right, I think, is really important. So I would recommend reaching out to Jeff and Billy, and I'm sure that the two of them would be able to connect to other relevant experts in that field. As Member Evans mentioned, connecting with at least one person from the Department of Hawaiian Homelands would be vital. They have had more struggles than anyone with the problem of these leasehold products. And I don't think it's a matter of just the qualification for financing, but it's a matter of who can qualify for financing. And so we need to take a more granular approach to that. And just the last thing is on Member Gordner's testimony, specifically regarding reporting to the board. I would love for the administrative rules to reflect an annual report that is publicly disclosed in terms of the data that's being collected through this program, both so that the board can understand what's happening, but also so that news media and the general public at large can see how these programs either are or are not working, and then the legislators can make amendments as they refine this pilot program. So being sure that we're collecting this data and making it accessible, including, as Member Gordner pointed out, to researchers, is going to be really important, because we have an opportunity here with this pilot program to chart a new path forward for housing in Hawaii. And, you know, the better we are at collecting the data, the better we'll be at improving the program. The better we are at improving the program, the more people we can get into housing. So I thank the staff for all the effort on this. I know it's hard to translate laws into administrative rules. It takes a lot of time and effort. And I'm grateful for all the effort you've put in. Member Yamasaki has a comment or question.
Oh yeah, thank you, Chair. That's a real nit, if I could, under subchapter 6 foreclosure. This is kind of referencing that based upon the prior testimony. If you look at the bottom of page 16, it talks about, you know, if the HCDA does not exercise its right of first refusal, then the mortgagee of the condominium may sell the unit in leasehold for a term not to exceed 99 years to any buyer. I was going to suggest that where it says may sell the unit in leasehold for a term of the lesser of 99 years or the remaining term of the original lease.
Thank you,
My
Member
suggestion.
Yamasaki.
Members, any other comments or questions? Just as a note, this is for information purposes, so the staff will take all of these comments into consideration, and when we return in a couple of months,
March 5th.
March 5th, then we will be having decision making on this. So seeing no other board questions, we'll move now to testimony. So do we?
So public testimony,
Yep.
we have
Oh, let me read. I'll read
yeah,
that.
go ahead.
Yep, so since the notice of the public hearing was published on Thursday, January 2nd, 2025, and written testimony was invited, as of today, the HCDA has received 3 written testimonies, 1 in support and 2 for comments only. We will now take verbal public testimony. We'll now hear testimony from the public. Speakers will be called upon to testify in the order in which they have signed up. Public testimony will be limited to 3 minutes each. Since each authority member has or will be given a copy of any written testimony that you might have provided, please refrain from reading your written testimony and instead summarize your comments in the time that you have available. When you are called, please clearly state your name and any organization that you are representing. The first person signed up is Tara Rojas. Please limit your comments to 3 minutes.
Aloha, can you hear me?
Yep,
Yes.
loud and clear.
Okay.
I'll start
Before
your
we
time. when you
begin,
start.
because I tried calling and you couldn't hear me on the phone. And so I wanted to know, one, where can we see these testimonies that have been submitted online? I have your guys' website open. And number 2, where is the previous public hearing from August 7th, 2024? Where is that recording, public hearing recordings and testimonies? Before I begin, because I tried calling and couldn't hear me yesterday.
The minutes for the August 7th meeting are on the website. And then the testimonies for this have been posted.
Okay,
So
where,
please-
because I looked online and for the August 7th recording, public hearing, and also testimony for
minutes.
this, I couldn't see it anywhere.
If you click on board meetings on the website and click
Yes.
authority, agenda, and materials, I
Yes.
just checked on my computer. Both the meeting minutes and the recording for August 7th are on the website.
The general meeting, okay, and then the testimony for this meeting right now, where are they? Where are they listed? Because I only see notice of public hearing, the 99-year leasehold program, but I don't see anywhere it says like the board material nor testimonies.
When you go to public hearings, pardon, this is Francine Murray from HCD. When you go to public hearings on the website, it has the hearing notice, and below that it says 99-year leasehold program. Click on the program for more information. You'll see more details about today's presentation, including the staff report, the draft rules, and at the bottom you see testimony received by this morning. Thank you.
Thank you, Ms. Ross.
Thank you,
Proceed.
okay. Yeah,
Proceed.
okay, and then before I start again, I'd like to respectfully note that the, HCDA as a public instrumentality of the state represents an entity whose actions are, in my view, fundamentally unlawful when viewed, through the lens of Public Law 103-150 and the broader decolonized mindset of Hawaii. Your development-driven agenda, driven by bylaws and corporate interests, continues to disregard Kanaka Maoli, not Native Hawaiian, Kanaka Maoli sovereignty, culture rights, and the spiritual connection of our people to the land. Adding a governor-appointed culture specialist does not make these actions lawful, is merely a token gesture that fails to address the systemic erasure of Kanaka Maoli rights. This is not just about development, it's about the further marginalization of our people and under a colonial framework that continue to disrespect true needs for sovereignty and cultural restoration. So with that, Aloha Tara Rojas, I'm testifying today in strong opposition to the proposed HRS sections 206E-281-294 and related rules, particularly this 99-year leasehold program and the lack of clear definitions, as you all mentioned, for, like the affordable housing. These provisions not only fail to meet the needs of Kanaka Maoli, but they also undermine the intent of Public Law 103-150, the U.S. Apology Resolution, which acknowledges the legal overthrow of the Hawaiian Kingdom and calls for the restoration of Native Hawaiian, change that to Kanaka Maoli rights and sovereignty. So I have just 4 points. 1, revenue neutral housing and Act 97. 2, the 99-year leasehold program. 3, Kama'aina displacement, just so you know where I'm at. And then number 4, the public apology law and its true intent. So the revenue neutral, as I was listening to you guys speak, the language used in this proposal suggests revenue neutral income housing, but it does not necessarily target low income individuals. Instead, you just said it's aimed at middle class, which is even more concerning. According to Act 97, low income criteria are not even necessary to include, which means this 99-year leasehold program is not designed to support the people it should. Middle class housing may seem like a benefit, but for Kanaka Maoli and many of our people already displaced, this is far from affordable. Your 400 to 600K price range is completely unaffordable for the majority of Hawaiians and Kama'aina included, especially for those who have been dispossessed from the land and who still suffer from the economic impacts of colonization. I attended, the Waianae board meeting, neighborhood board. This would be, unaffordable for the people attending. So number 2, 99-year leasehold program. The 99-year leasehold program proposed here is not just unaffordable, it's a continuation of the disempowerment of Kanaka Maoli. The lack of affordability in these
Ms. Rojas, can I ask you to please summarize your testimony?
Yeah,
You've reached 3 minutes.
But I just have 2 more, and I know there's nobody else.
I'm asking you to please summarize your testimony because you've reached 3 minutes.
So that first part wasn't part of it, but so Kanaka Maoli are further pushed out of the land, displaced, and basically the state, this illegally occupying fake state, continues to disregard Hawaiian sovereignty and the cultural rights they hold to Aina. And this will somehow, the idea that this will benefit middle class people.
Ms. Rojas, I can give you 15 more seconds, but then we're going to have to cut you off.
At the expense of Kanaka Maoli is a misunderstanding. So as a Kama'aina, we understand the real cost of living is beyond what's presented as affordable, and Public Law 103-150, you need to hear this, is meant to restore Native Hawaiian sovereignty and provide reparations for.
Okay. Do we have anyone else signed up to provide testimony?
No,
Okay, do we have any persons present in the room wishing to provide testimony?
no, Chair.
Seeing none, I will proceed with closing today's hearing. The time is now 9:55 a.m. Take a 5-minute break
5 minute.
and we'll start the next meeting at 10 a.m.
Thank you.